The U.S. death penalty system is plagued by many problems that undermine its fairness and reliability. In this section, we will explore some of these problems, such as lack of proper disclosure, underfunded defense, rushed appeals, racial bias, and unreliable eyewitness testimony. One of the problems with the U.S. death penalty system is the lack of proper disclosure of evidence by the prosecution. According to the Death Penalty Information Center, DPIC, more than 100 death row inmates have been exonerated since 1973, and many of them were convicted based on withheld or fabricated evidence. For example, Anthony Ray Hinton spent 30 years on death row in Alabama for 2 murders he did not commit. He was freed in 2015 after it was revealed that the state's forensic experts had lied about matching bullets from the crime scenes to his gun. Another problem with the U.S. death penalty system is the underfunding of defense counsel for indigent defendants. Many death row inmates are poor and cannot afford to hire qualified lawyers to represent them at trial and on appeal. As a result, they often receive inadequate legal assistance from overworked, inexperienced, or incompetent attorneys who fail to investigate their cases, present mitigating evidence, or challenge prosecutorial misconduct. For instance, Robert Lee Willie was executed in Louisiana in 1984 despite having a lawyer who slept through parts of his trial and did not call any witnesses in his defense. A third problem with the U.S. death penalty system is the rushed and restrictive nature of the appeals process. Death row inmates face numerous procedural hurdles and deadlines to challenge their convictions and sentences in state and federal courts. Many of these rules are designed to limit the scope and length of review, rather than to ensure the accuracy and fairness of the outcomes. For example, Kevin Cooper was denied a hearing on new DNA evidence that could prove his innocence of 4 murders in California because he missed a filing deadline by 3 days. A fourth problem with the U.S. death penalty system is the racial bias that affects its application. Studies have shown that race plays a significant role in determining who gets sentenced to death in America. Specifically, defendants who kill white victims are more likely to receive the death penalty than those who kill black or Hispanic victims, regardless of their own race. Moreover, black and Hispanic defendants are more likely to be wrongfully convicted and sentenced to death than white defendants. For example, Troy Davis was executed in Georgia in 2011 despite strong evidence that he was innocent of killing a white police officer. 7 out of 9 eyewitnesses recanted their testimony against him, but the courts refused to grant him a new trial. A fifth problem with the U.S. death penalty system is the unreliability of eyewitness testimony. Eyewitness identification is one of the leading causes of wrongful convictions in capital cases. Many factors can affect the accuracy and credibility of eyewitnesses, such as stress, memory distortion, suggestive police procedures, cross-racial identification, and social pressure. For example, Carlos de Luna was executed in Texas in 1989 for stabbing a white woman to death at a gas station. He was identified by a single eyewitness who saw him running from the scene. However, years later, investigators found evidence that another man named Carlos Hernandez had committed the crime and confessed to it several times. These are just some of the problems with the U.S. death penalty system that make it unjust and unreliable. The death penalty is not only a violation of human rights, but also a waste of taxpayer funds and a source of pain and suffering for innocent people and their families. It does not deter crime or provide justice for victims. It is time to end this cruel and ineffective practice once and for all.